Okay, everyone. So I have now calmed down. I was hungry. I had to get something to eat, stabilize my blood sugars, and then I went back and I reread this letter, which was the supplemental letter that Lively filed seeking leave to file a 5-page letter to the judge, etc., which she seems to like doing. So, and as always, I did say in my video, I'm sure there's a really good reason. Just right now, I'm not seeing it, but I've gone away and, with a clearer head, looked at everything a bit better, a bit more closely, and I'm a lot less pissed off. um, so let's just go back here. I should know myself better by now, right? And I've been watching what Lively does for nearly 2 years very carefully, and I should absolutely know what she does and why she does things. I think she came under fire. I think this letter now is PR, like everything else, right? I think it's all PR. I think she came under fire because there's so much chat online about, oh, what happened to she was going to see it all the way through, for the victims, survivors, and all this stuff, and kind of just trying to tie herself as an ally to women who have survived, kind of domestic sexual, abuse, assault, harassment, etc. And not just women, children. She also put children in that Instagram post that she did, along with her dragon emoji. And I said this on X, right? When she went to the Met Gala, I put up a post. I was like, really? In fact, I feel so strongly. I'm going to find the X post because, like this case during the marketing period, right? I think it's important to sort of look back and say, what were we all saying at the time about how Blake Lively was behaving? So I'm going to quickly share this. And this is what I put up. And I know many other people, said the same thing, right? And you even had some people who were kind of behind the scenes at the Met Gala coming out and going, what was going on? What was she thinking? I quoted Lively's complaint. I don't know why it's formatted itself like that, but never mind. The emotional impact on Ms. Lively has been extreme, not only affecting her, but her family, including her husband and 4 children. There are days when she has struggled to get out of bed, and she frequently chooses not to venture outside in public. And that has been one of the final paragraphs before the causes of action in at least the first 2 complaints and the CRD from Lively. I think it got removed for the second amended complaint because she had withdrawn her intentional infliction of emotional damages and distress. And then I went on to say, I kind of responded to that and it's like, yeah, then she settles the lawsuit. The trauma suddenly falls away. She makes a full recovery at breakneck speed, hops out of bed, rushes to the Met Gala, still wearing her bedspread, and true to form, inserts herself in something she wasn't invited to make it all about her, right? And that was a dig because the Met Gala was saying that she hadn't even been invited. And I found it hysterical. Oh, great. Another thing she's not been invited to, which she's kind of, decided she's going to the party anyway. And then I had a jab about her husband not showing up as well in a show of support. And then I said, it's as if she was never traumatized at all, right? And the thing is, right, is a lot of people felt the same very strongly, like, well, hold on a minute. Wow, you bounced back there from that trauma really quickly. And what happened to, taking a stand for all women and children who've ever suffered this? And I think people kind of felt really used, like their experiences were being exploited. Their hardships were being exploited for Blake Lively's gain. And then I looked at this and I was like, She's throwing everything into this letter. This has got absolutely everything. It's got absolutely everything in it. Oh, look, we know, Judge, we've settled this. We've settled it. And I'm definitely the prevailing party in the Wayfarer v. Lively action. And then she's put all the kind of the charged wording of section 47.1, right? You know, and it refers where everything that refers to victims and survivors. So here, the California legislature enacted this privilege to provide a clear, unambiguous pathway to justice for victims of sexual assault, harassment, and discrimination. And this part here, moreover, because section 47.1 protects victims from litigation itself, these remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing protracted legal process. So although she's like, so you owe Ms. Lively, she's kind of throwing in the language which is, I'm doing this for the victims. I'm taking my stand. I'm still fighting for you. But really, this only benefits her. And I was like, why did Wayfair leave it in? There's going to be a reason. I just can't see it. And I couldn't see it because I was like really pissed off. And my sugar levels were not great. But then I was like, no, I need to step back. And I did. And I was like, her claims aren't actually proven. I mean, section 47.1, it's conditional, right? It's conditional in the sense that you have to meet certain objectives. Yes, you do not need to have filed a complaint about sexual harassment, but you have to have had a reasonable basis for, to have filed a complaint. Okay. You also have to have done it without malice. Great. And while earlier I looked at the motion for summary judgment order, and I looked at the wording, and the judge did say, well, a jury could believe that she had been that she had a reasonable belief that she'd been sexually harassed. He did say that, and I was like, oh God, that's not helpful, and it's not. But at the same time, it's not a definitive, he's saying that's what his opinion is. He's just saying a jury could, presented with all the evidence and the facts, they could look at the case and go, well, yeah, actually, I can see it. But the problem is Lively has now withdrawn her intention to proceed to trial by settling this case. So the jury are not going to get to look at all the facts and the evidence. They're not going to hear the testimony, which means when looking at this motion and deciding it, neither is Judge Lyman. Yes, there's a lot of evidence which he will be aware of, but it's not all the evidence. It's not the same. It's not the same as, the kind of the case put forward. And the problem is, Wayfarer wanted to bifurcate the whole damages element too, because it was such a lot. And they wanted to bifurcate the damages side and set it aside separately, away from the main part of the trial. And that is because there was going to be a lot of money is being asked of here. Like these are substantial damages. And I would be surprised if a judge was prepared to just kind of rule on this and say, yeah, sure, I'll just hand over, all this money and treble it as well. Because this is a case of first impression. So I think Lyman is going to, I got the impression he didn't want to do it anyway, but I really think he's not going to want to do it under these circumstances, because his ruling will set the precedent going forward. And you don't want to be doing that if you're bypassing the trial, really. I don't know. I mean, I do get, though, it does say it should be done at the earliest convenience, blah blah blah. Typically through a motion to dismiss. But I think that's just ridiculous. I think that's where the law is actually flawed, because a motion to dismiss can happen so early that, you know, how can you be sure that Lively has met all of the elements that make her eligible for this, such as, the lack of malice, which Judge Lyman did not say in in his order on the motion to dismiss. Judge Lyman did not say that Lively's actions did not have malice. He said that about all the other defendants, but not Lively. I'm just thinking in my head. So I'm really I think I would struggle with the thought process that Lyman would entertain this, and I think the reason for that I did for a few minutes think, oh, well, that's it now, it's a done deal, is because about something like 91% of his rulings have gone in Lively's favor, and it was a bit unpalatable, really. But I do trust Friedman entirely. I trust Friedman. I do not think they have made a bad move. I just had to think about it for a bit. What else is there? Yes, this is the other thing that bothered me, is this bit here, right? The alleged defamatory statements that formed the basis of the Wayfarer Party's retaliatory lawsuit satisfy all elements of privilege under Section 47.1 for reasons that have already been raised in this court. The thing is, right, is Wayfarer were arguing that their statements were protected through litigation privilege, and no decision has been made on that. So I think that's another issue for Lively. Yes, this bit as well. So she's respectfully requesting leave to file a short supplemental brief of 5 pages or fewer to address any impact of the court's intervening rulings since the 47.1 motion was filed, and to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, and costs issues in light of these developments. The problem is, right, is she's saying that she wants to be heard by the court, but she's also, by settling, waiving her right and dismissing her claims, waiving her right to be heard by the court. So that's a problem too. And I had to laugh at this. Several of the Wayfarer parties agreed to stipulate that Miss Lively, when we say several, right, we're talking about 3 out of the 8 parties. And the only 3 that were still parties in the entire case, given that several of her claims had been kicked out. But several of the Wayfarer parties agreed to stipulate that Miss Lively engaged in protected activity, which encompasses the element of good faith, reasonable belief that she complained of or opposed unlawful harassment. Okay, I have a few things to say about that. In fact, I got a lot to say about that. Okay, where is it? All right, we'll start with Wayfarer's actual letter where they agreed to the stipulation, right? This is obviously the stipulation that, Wayfarer would agree that Lively had engaged in protected activity for the purposes of, for basically the protected activity element of Lively's 4th cause of action for retaliation of California's Fair Employment and Housing Act. Now, Lively seems to forget this very, very important part here, because I think she wants to dump this and remind, basically the public who are reading this. Don't forget, Wayfarer agreed to this, right? Which is what I said was going to happen. in my last video. But Wayfarer only agreed to it for the purposes of the trial. Well, the trial's not happening, so she cannot use this. And I'll go one further. Do we all remember this letter she filed? I'll read it. Dear Judge Lyman, on behalf of plaintiff Blake Lively, we write pursuant to Rules 1C and 4C of Your Honour's individual practices to respectfully request leave of this court to file by May 1st, 2026 at 5 p.m. a letter brief of no more than 5 pages in response to defendants Wayfarer Studios, It Ends With Us movie, etc. Wayfarer defendant's letter. Dated April 29th, 2026, informing the court of their agreement with respect to the protected activity element of plaintiff's fourth cause of action. Ms. Lively's letter brief will address her position on the agreement and her understanding and position on the implications of the agreement for evidentiary and other issues outstanding in the case. Now, the only reason she felt the need to write a letter is because she disagreed with the stipulation. And we all were like, okay, what's she want to say? Well, we never did find out because Judge Lyman told her, no, you can't file a letter. He was prepared to hear her at the experts, the Daubert hearing that was due to be, I think, tomorrow, but is now not going to be happening. But the only thing I could see happening here, there's two possibilities. Is firstly, she didn't agree at all because she realized it puts her in a bind. And, she wouldn't have been able to get in all that evidence of sexual harassment, put on some of the witnesses and some of the experts, etc. And all the stuff that would have generated her headlines. She wasn't going to get to do that, and she weren't happy about it for some unknown reason, because that stipulation was entirely for her benefit. For the purposes of the trial, it's an element she now does not need to prove. The jury were allowed to presume it. To presume it was true. So that actually would have saved her a lot of time and effort, but she wanted that time and effort, is what I think. Now, alternatively, she could have actually filed a letter saying, hey, we agree with this. However, we don't agree that it's for trial purposes only. In which case, you would have seen the fastest response from Wayfarer saying, no. We're not doing that. In the words of Jenny Slate, we're not doing that. It would have been, no, you can have this for the trial because we don't agree to it, but we will agree to it for this purpose, solely for this purpose, in order to help, move everything along and speed things up. And there would have been a big fight over that. And if Lively refused to back down, then Wayfarer would have probably withdrawn the stipulation. So there was absolutely no way that stipulation came about in the way that Lively is representing here, right? And she's just saying, well, they just agreed that I engaged in protected activity, so that kind of satisfies now the element of good faith and reasonable belief. Therefore, job done. And she's abusing that stipulation, and the judge is not that stupid, and he's not that in favor of Lively either. So I don't believe he's going to accept this. I think there's a chance he might let her just file it anyway, and I hope he does. But he also could say, no, not a chance. But I don't think he's going to allow it. I still think she's got the better shot over in Texas, where she's seeking all of this from Jed Wallace, which I think is, I just can't even believe that situation has been allowed to happen, because Jed Wallace clearly had he was so far removed. Even if her allegations were true, Jed Wallace was so far removed from them and literally had no motive to retaliate or aid and abet or do anything else that he's been accused of her. He was hired to do a job, and he did a job. That's the end of it. But I do not think there was any intention to, harass. Well, he certainly didn't harass her, but there was no intention to, facilitate and aid or abet any retaliation. So I think it's absolutely wild, but I still think that's the best route for her to get the Section 47.1 damages. However, I will be so angry if that happens, though, because that is an injustice, in my opinion. But for the purposes of this now I've calmed down. Now I've kind of gone back with a clear head and looked at everything and gone back through other stuff on the docket, and just thought about Lively and how she acts and what she does and how everything has a motive. Nothing is an accident and nothing is done without a specific purpose. And then I thought about everything I've ever learned from Ashley Brianna Eve. And I just put it all together. I was like, no, that's what's going on here. This is a PR thing that wraps up everything now, because that statement, it had a lot of us going, hold on a minute. That almost sounds like an admission there. That's not what it was, right? Friedman come out and said, no, that's not what that was. It's just, Lively deserves to be heard, but, and then he clarified, so does Justin Baldoni, and Justin Baldoni wants to tell his side of the story, and I can't wait to hear it. Then we had, the notice of settlement stipulation, which made me think a little bit. It's like, oh, okay, they're leaving this on the table. Interesting. But the reason it didn't make sense to me in the first place is because when you settle a case, normally your right to continue to have a claim heard is waived. So it made no sense that they were allowing one to stay on the table, because in that case, the case isn't settled. And settlements are normally full and final. But the door was being left open for part of it, and it didn't make sense at all. But now, and I thought, to be honest, oh, maybe it's something in the, the American law, then maybe I need to go and look up about it. But no, that's quite a standard thing. And it's still the position now. Lively is, just using that kind of that part of the stipulation, which is never going to go anywhere, to write this letter and possibly follow up on another 5-page letter to be able to sort of say, to the public, for the public's benefit, oh, don't forget, we've agreed to settle this, but, they basically admitted, the stipulation, and I'm doing it for the victims. And then, I think she's rehabilitating the backlash she got for the Met Gala as well, where people were criticizing her for saying, one minute, oh, I'm going to be there, I'm going to defend all the victims, I'm doing this for all the victims, I want to see us get to trial, the retaliation was always the main part for me, etc. And then she walked away from it, went to the Met Gala wearing a parachute, and then and then she's put this letter out there to kind of say, hey, here's all the language of Section 47.1, everything that refers to survivor or victim or something like that. And she'll be able to say, look, I did my best. The judge said no. What was I going to do? I think that's where this is leading to. And it's very on brand for Lively. Very self-centered and self-serving. I'm massively disappointed in her that she is still doing this, when all she had to do was just address domestic violence. This is something I've said like over and over again. Like, all it was a little bit of effort during the promotion to acknowledge the survivors. But even when she was asked directly about it, the jokes, the sarcasm and everything, I don't know who thinks that it was appropriate moment to have a joke. And this is what I said. This is why I'm so annoyed with Colleen Hoover with her reasoning for preparing Blake Lively's version of the film, is because it had more humor in it. There was nothing humorous about the situation, and these women would understand that if they'd ever remotely experienced it, but they clearly have not. So that is my take on this. Now, I now feel a lot better. I feel I feel a lot better. Yeah. It's been a lot of emotions, guys. You've been with me through it all. We were all shocked the other day at the announcement of the settlement. We were all pissed off when we saw Lively go into the Met Gala, and then this. And as I said, like, I looked at it and I was like, but you, you know, these kind of settlements don't normally leave things open. So what is going on here? And I did feel like, on first glance, Wayfarer were being played again. But now I've looked at it with a clearer head and a calmer, what's the word? You know what I mean? Like, just a calmer aura or something like that. I do feel a lot better about it. I think it's going nowhere. I think my only concern was, it's Lyman. Lyman gets to make the decision, and there have been a lot that has gone in Lively's favour. However, I do have faith, though. He does not want to rule on this. He does not want to be the first to rule on it. So, yeah. Okay. Let me know what you think, though. Does that make some sense? And again, as always, do ask questions. If you've got questions, I'll try to answer them. I am working through everyone's comments from the last few days. There are just such a lot. It's taken a little while, but I've gone through quite a few.